SJC-12058, Commonwealth v. Wayne L. Miranda.
Good afternoon, Mr. Shaw. We appreciate your patience.
Thank you. Chief Justice Gantz, and may it please the court, my name is Robert Shaw. I'm privileged to
You
appear.
mind waiting just a minute because I can't hear you?
Okay.
Thank you.
We'll give you an extra few minutes.
I'm privileged to appear on behalf of Wayne Miranda. As the court is aware, we're here today because a federal judge has sua sponte stayed Mr. Miranda's habeas litigation so that the issue now before the court can be addressed. And I think it's accurate for me to observe that as I stand here today, I'm in what reasonable people could reasonably characterize as a difficult position. In fact, it's hard for me to imagine being in a more disadvantageous posture. And the reason for that, obviously, is that the court has made certain judgments about the standard announced in Zanetti, and the court has acted on those judgments. And what we are asserting is that the court has looked at the Zanetti standard incorrectly, and that the application of the Zanetti standard to Mr. Miranda violated his due process rights.
The part that I don't get, and you are a man of courage, so you don't need to worry about taking a courageous stand. We expect that of you. Let's assume you're right. Let's assume that the pre-Zanetti standard applies. This court in Miranda said, even if it did, there was evidence that is sufficient to support a finding of that he was a principal or that he was a joint venturer. And it even said a sentence: if you credit the testimony of Andrade and Rodriguez, then you say he was a principal. If you credit Fagbimi, then you say he's an aider and abettor, a joint venturer.
Well, Your Honor.
So, I mean, don't you lose even if you're right?
Well, no, I don't think so. And I think that gets into a very detailed analysis. What the court did in the Miranda decision was a very truncated analysis. And as the court indicated, Zanetti was the standard that was applied. And the analysis that took place, which was very condensed, was measured against the standard of knowing participation. The fact that the opinion references a shooter versus not a shooter doesn't mean that the court engaged in a pre-Zanetti analysis.
So what do you say that pre-Zanetti analysis would be?
Well, I think that's very important, and we need to get into that. But if I could, what I want to do initially is simply look at the Zanetti standard and the way the court has looked at it and why that's incorrect, because I think that's very important, because the court has essentially taken the position, and the approach that the court has taken is that Zanetti was not a substantive change in the law, okay? And it seems to me that, respectfully, that is a position that is grounded primarily in the abstract. And what I mean by that is that the court in the Zanetti decision looked at the history of our jurisprudence and the way it evolved, and essentially says, look, we're going to make this easier. We're going to get rid of some of the complications that occurred relative to the principal joint venture frameworks that we were working with. We're going to streamline the language. We're going to streamline the analysis on appeal. And they're essentially similar and to the same end. And that, of course, is what the Commonwealth is saying. The Commonwealth is saying the Zanetti decision is just a change in vocabulary, and no elements were changed. Now, the problem with that approach is it doesn't measure how the change impacts a defendant when the new standard is applied. I mean, the court's language in Zanetti is vocabulary in the abstract, but when applied, it completely transforms the trial process.
But if you're right, that meant that before Zanetti, where you had a case in which it was absolutely clear that the defendant either was the shooter or handed the gun to the shooter, but you really couldn't be sure as to which one, and therefore the jury could really not determine beyond a reasonable doubt whether he was the shooter or not because the evidence wasn't strong enough. In that case, under your view, he'd have to go free because no reasonable jury could say he was the principal, and no reasonable jury could say he was the aider and abettor, and since no reasonable jury could do either, then he walks away, even though any reasonable jury would say he did one or the other.
Well, if any reasonable jury would say he did one or the other, then most likely there's sufficient evidence to draw the inference and come to that conclusion. The problem that occurs is when you have a general verdict and you don't know what the jury has relied upon. And that's really what happened
But in my
here.
example, if you had a specific verdict, it would be not guilty as to both because the jury may say we have a reasonable doubt on both theories. We're not sure he's the shooter. We're not sure he handed the gun. We can't be sure of it, so not guilty as to principal, not guilty as to aider and abettor.
Well-
There's no line that says we know he did one or the other.
That's not this case in any event, right? I mean, that's not this case.
Well, that's what this court said.
Well, I mean,
In Miranda, this court said that we think there is sufficient evidence as to both theories.
If we look at the impact, I mean, the elements certainly down at the trial level are changed, right? I mean, there's no doubt about that the elements are reduced.
In what respect?
Under the Prisonetti framework and in accordance with the jury instructions in this case, there were 5 elements that the jury needed to look at and analyze and find beyond a reasonable doubt in order to convict. Under the Zanetti standard, it's reduced down to 2.
Presence?
Right, there's
Yeah,
a
but-
number
but
of
of
them, and they're
course-
listed in the brief,
But
right?
presence wasn't even pre-Zanetti always required. I mean, look at Ortiz.
Well, there was presence, there's, agreement, there's knowledge that another person is going to commit the crime. There is, proof that somebody else did it, okay? So then that obviously is a reduction in the quantum of evidence required for a conviction, and that changes the nature of the evidence required for a conviction. And, of course, the available arguments at the directed verdict stage are reduced. The analysis that the trial judge needs to go through is changed. So all of these are pretty significant changes, and we suggest that they are substantive changes, and they affected Mr. Miranda during the course of his case. Now, the real question here, obviously, is how did this play out during his case, and why was there a violation of due process? Well, it played out during his case because first, his entire trial process was based on Prisonetti law, the rules governing the process, the thinking and strategy of his attorney, the analysis that the judge needed to go through in ruling on issues, the rulings that she, in fact, made. All of this happened based on Prisonetti law. Then Mr. Miranda had a right to appeal based on the events and the rulings and the analysis that took place at trial, and he did that, and we formulated those arguments. But the court resolved those issues by applying a different standard of law, not the merits of what we had raised, not what happened below. And so that's exactly what the court said. We're resolving this because it no longer matters who shot the victim. And the court cited Zanetti, went through a very brief analysis, then cited Zanetti again, and that was it. It no longer matters that there was a general verdict. And that is really, I can tell you, as somebody who appears before the court quite a bit, that just hit me from behind. I mean, we had no idea, we had no notice, we had no understanding. We were the first case where that happened. So, Wayne Miranda is very uniquely situated as compared to any other defendant, because during that process, anyone else would have at least had the Miranda decision to understand we can file something to re-argue this, or raise some other issues if they had not understood it, as we didn't understand it. With respect to the pre-Zanetti analysis, I do want to mention that that's a complicated analysis. If the court agrees with us that there was a problem here and rules on this legal issue, which is really what is before the court, and the court wants to address a pre-Zanetti analysis, I think that the court should allow at least a minimal amount of briefing to address it, because it's a very complicated issue. There was one witness who actually saw what happened in this case. And I think that the other significant problem is that in the court's decision in Miranda, respectfully, the court omitted very, very significant facts. And those facts, just to mention them so you're aware, when Wayne Miranda was running, after his brother's trying to stop him, this witness runs to the window and she yells out the window. This was not included in the court's decision. "No, Wayne, no, think about your daughter, think about your daughter." He stops, looks up, turns away from where the victim is. His brother, who's just been trying to stop him, runs up and he hands the gun, okay? Those facts were not addressed by the court, and I think they're extremely significant, as well as some others, and so I would ask for the opportunity to address them if the court's going to rule in our favor. Thank you.
Thank you. Ms. Stern, we thank you too for your patience.
Thank you, Your Honors.
Could you start with what Mr. Shaw just said about the evidence? I'm just interested in that. The no Wayne stop.
I'm afraid I'm not as familiar with the details of the transcript as I know the case was briefed and argued on direct appeal, but I admit I'm largely familiar with the facts as this court found them, which was the defendant's position in his brief was sort of the be-all and end-all. But I think that it's not, based on what I've just heard, this court said that I believe that Ms. Rice was shouting out the window at the defendant, and it said that she is the witness who said that he handed the gun to Fagbemi. The other witnesses didn't see that, so I don't think the fact that he looked up when she yelled adds anything to the fact that the jury could have believed her, could have not believed her about that particular point. I think we would still be in the same place as this court ruled, again, after having had this issue briefed thoroughly and argued at the time of the direct appeal. On my brother's point about what the jury was instructed in a trial, according to the section of the jury instructions he includes in his appendix, the judge instructed the jury in joint venture as it then stood, and then said, if, however, after your consideration of all the evidence, you conclude that the Commonwealth has not proved any one of these five elements beyond a reasonable doubt, and also that it has not proved beyond a reasonable doubt all the elements required to prove Wayne Miranda guilty of murder in the second degree based on individual liability, then you must find Wayne Miranda not guilty of murder. So there were specific elements for joint venture and for principle, but they were not, essentially it was being presented to them even then, sort of in the aggregate. You must find one or the other.
And what were the five elements that were listed there? I just don't remember.
I would.
Oh, you don't know? I'm
yeah,
sorry, I thought
unfortunately,
they
I
were
would
right
have
there.
to
Never mind.
pull the brief, but and I know my brother discusses it at length. But so essentially, they were given a much more complicated instruction, but I would argue it really did amount to the same thing. And I would argue, as I did in my brief, that this court did squarely address the defendant's sufficiency arguments that he raised in his direct appeal, even though they were discussing them in the context of Zanetti. They hit on every point that they ever would have hit on had they decided the case before Zanetti, and properly decided that Zanetti did not change the game and that there was sufficient evidence in any event of all of the theories of joint venture of liability that were before the trial court. Any further questions? The Commonwealth rests on its brief. Thank you, Your Honors.
Thank you.
It's been an honor.
All right.